Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video would suggest, we're going to be talking about the non-immigrant visa unit here at the U.S. Embassy in Bangkok, Thailand. Why are we talking about this? Well, there is a difference and there's some nuance and there's a little bit of information that can be gleaned by understanding the difference between the two visa units that deal with visa application adjudications through the consular section here at the post. So the non-immigrant visa unit is different from the immigrant visa unit insofar as the visas being adjudicated or the applications for the visas being adjudicated are non-immigrant in nature. One of the big differences between the immigrant visa unit and the non-immigrant visa unit is the non-immigrant visa unit is going to more frequently utilize Section 214B of the Immigration Nationality Act when analyzing visa applications which come under their rubric. So to sort of get to the point here, there's another video on this channel which specifically gets into Section 214B of the Immigration Nationality Act. For anyone who's ever, especially here in Bangkok, had a girlfriend or a spouse try to apply for a tourist visa to the United States, those folks are going to be well aware of Section 214B, or many of them will be, because there's a very high, I shouldn't say very, but there's a rather high denial rate of applicants, especially female applicants, quite frankly, applying for tourist visas to the United States and being denied under Section 214B. It just is sort of what it is. Under Section 214B, the adjudicating officer needs to go ahead and make a determination whether the person applying has strong ties to their home country. In the case of Bangkok, that's probably going to be Thailand, or a third country outside the United States, so that's not Thailand but some other country, and weak ties to the United States. If it's determined in the consular officer's discretion and sort of through their investigation that in fact that applicant does not have particularly strong ties that they deem would overcome their desire to stay in the United States, that officer can go ahead and adjudicate that application as denied. This is a rather frustrating process, I understand, for some folks, because it's just simply rather frustrating to have an application for a visa denied. But that being said, pursuant to the doctrine of consular absolutism or consular non-reviewability, coupled with the provisions of Section 214B, this rather frequent occurrence, although somewhat frustrating, is rather common, and frankly, under the law as it sits, it's probably what they ought to be doing. Again, each case is going to be factually different, and again, intentions, I would actually argue, just from a practical standpoint, that there actually was a time when tourist visas were adjudicated with, I guess, more, for lack of a better term, with less scrutiny, or perhaps were adjudicated a little bit more liberally than perhaps they are now. That being said, there was, in the past especially, there was quite a large frequency of folks that were coming into the United States in non-immigrant visa status and utilizing their ability to get presence through one of those types of visas to go ahead and circumvent the system by which one is supposed to immigrate to the United States. So in a way, there's kind of an element of this where it's like, look, in the past, a few bad apples kind of ruined it for everybody. Also, a big change, especially with respect to the non-immigrant visa unit, and this is somewhat before my time, but I have read a fair amount about it, and I do sort of understand the ripple effect it had in the aftermath, is unfortunately, as a result of 9/11, it became a requirement in the years thereafter that all non-immigrant visa applicants, at least at the post here in Thailand, actually receive an in-person interview. And the upshot of that was that a lot of these folks were getting denied more often. Whereas with just a pure paper application, it seemed like the frequency of denial was much, much lower. So these are just some observations specific to sort of non-immigrant visas and denials thereof, and sort of perhaps some insight into why that happens. Something else to note, and it's noted in the other video with respect to the immigrant visa unit, K-1 fiancé visas, although a non-immigrant category, are treated for purposes of consular processing, at least at this post here in Thailand, as if they were an immigrant visa. And in a way, there's sort of a hard immigrant intent associated with the K-1, notwithstanding the fact that it is a non-immigrant visa, that effectively makes it, in all but name, an immigrant visa. So it's effectively treated as such for purposes of consular processing. So when dealing with the U.S. Embassy, I would assume maybe even in other jurisdictions, but at least for sure in here, You're not going to be dealing with the non-immigrant visa unit, you're probably going to be dealing with the immigrant visa unit.